Hi, this is Scott Pierce. Today's seminar covers the most difficult subject on any bar exam, contracts. Contracts is the most difficult subject because not only is it the most complicated, but you've got to know two whole different bodies of law, the common law and the UCC. And although this subject also happens to be the most difficult subject on the multi-state, in my opinion, on essays it can be especially brutal. So this seminar is designed to make contracts as straightforward as it can be. And the good news is a rigorous, thoughtful approach to contracts can make it an awful lot easier to write winning essays than a sloppy approach. So take a look with me at the document that I've provided. This approach to contracts, like the one to torts, includes both a minimalist and an elaborate approach. Let's start with the minimalist approach and get the big picture. There's one or 2 points that I want to make up front. Notice that I offer a 6-part approach to contracts, and there's nothing intuitively unfamiliar about any of this. We begin with formation. Next, defenses to formation. Third, breach. Fourth, defenses to breach. Fifth, remedies, including our old standbys of damages, restitution, and equity, here's specific performance, and also we include the 2 remedies that are distinct for contracts, reformation and rescission. And then, finally, I offer in number 6, defenses to remedies. The most important point that I have for you up front is this. Notice that the defendant has 3 different places in our analysis at which he or she can interpose defenses. There are defenses to formation, defenses to breach, and defenses to remedies. And we're going to see more than one question that focuses our attention directly on the defenses. And what that means is we've got to consider the possible defenses a defendant might offer at each one of these 3 steps of the analysis. Just that insight could well be enough to earn you significantly more points on a contracts essay than you might make otherwise. So now please turn to the elaborate approach, and let's think about contracts in a little bit more depth before we get into our seminar questions. Obviously, everybody understands that the first judgment we've got to make about any given contracts question is whether or not we've got to apply the UCC or the common law. So, is it a common law question or does the UCC apply? Next, I suggest it's also appropriate to try to figure out who the good guy is and who the bad guy is in a given contracts question. Who is genuinely aggrieved? Obviously, in many contracts questions, the parties are very angry with each other. But usually, one party clearly is in the wrong. Once we have those threshold issues resolved, we're ready to consider how to think about contracts in a much greater depth. First, we begin with formation. And most first-year law students know the basics of this law well before Christmas, the first year of law school. Formation includes offer, acceptance, and consideration. And it seems to me that of those, the offer often is the most complicated. The offeror has to have an intent to be bound. The offer has to have a sufficiently precise content, and that offer has to be communicated to the offeree. We'll look at least a couple of questions that have fairly strong formation issues. Interestingly, of the formation issues, consideration is one of the more infrequently tested issues. Unfortunately for you, I am going to roll out a question that has a big consideration issue in it, probably as big as has ever been tested in the California essay section. So you'll have a chance to get a good look at it. After formation, we consider defenses to formation, and our elaborate approach lists all of the common defenses to formation: incapacity, infancy, fraud and duress, the statute of frauds, and mistake. Of those 5, the statute of frauds and mistake probably are the most commonly tested issues on California essay questions. Next, we consider the terms of the agreement, both express and implied, realizing that under the UCC, more terms can be implied than under the common law based on prior dealings and custom and usage. Finally, with regard to oral contracts, we consider the parole evidence rule with regard to establishing the terms of the agreement. Next, I suggest that we should consider rights of non-contracting parties. Primarily, this is where the third-party beneficiary issues fall, especially those with regard to when that third party's rights vest sufficient as to give that third party litigation rights against the other parties to the agreement. We consider assignment of rights and delegation of duties. Remember that a delegation always creates a third-party beneficiary, whereas an assignment only does sometimes. Next in our elaborate approach to contracts, we consider conditions, both satisfaction and discharge, and sometimes the exclusive conditions. The next big picture element of our elaborate approach to contracts is breach. And clearly, breach is a very heavily tested issue. In order for a plaintiff in a contracts action to have a valid theory of liability, he or she has got to prove that the other party was responsible for breaching the agreement. Notice there are three different levels of breach: a minor breach, a material breach, and a total breach. We could think of these as being equivalent to little, medium, and big, but notice, as I discuss this in our approach, I give you a little bit of black-letter law about the differences between minor, material, and a total breach. When we get to the total breach analysis, we need to be concerned about whether some earlier part performance could be split from the remaining breach of performance, the so-called divisibility issue. Next, we consider defenses to breach. The biggest of these are impossibility and impracticability. These two are almost always tested together, and I advise you to consider impossibility and impracticability together, in much the same way that we consider contributory and comparative fault together as defenses to negligence. Next, frustration of purpose, and then finally, novation. These elements can be relevant to defenses to breach under the right circumstances. In the next section of our elaborate approach, we consider remedies. Here, damages have the same function they do in torts. Damages serve to compensate an aggrieved plaintiff, with our intent being to make that plaintiff whole. In other words, to put the plaintiff in the same position that the plaintiff would have been in had the other party not breached the agreement. And again, just like in torts, we consider restitution by looking at the defendant. And our question is, has this defendant been unjustly enriched? And if our answer is yes, we are going to award money damages to the plaintiff, but technically they aren't damages. The money damages remedy is based on restitution under these facts. Remember, damages make the plaintiff whole. Restitution prevents the unjust enrichment of the defendant. Next, in my elaborate approach, we consider reformation and rescission. We'll see those issues play out to some extent in our work together on the essays. Also, we see them commonly on the multi-state. Finally, the last big remedy in contracts is specific performance, equitable relief in contracts. And here, once again, I'm not doing anything imaginative or original. All I'm doing is listing the elements that we need to consider when we do a specific performance analysis. Is the legal remedy adequate? Is there a definite and certain contract? Would it be feasible for a court to issue a specific performance order? Is there mutuality of remedy? Really a non-issue, since we almost always will overlook any deficiency in that regard. And then, defenses to equity. Here again, remember that a defendant can replay defenses to the theory of liability as a defense to remedies. And also, there may be specific remedy-centric defenses that a defendant offer at the remedies analysis stage. And we get to defenses to remedies. Notice I list the most common ones here in contracts, the idea that damages are speculative or that damages are not foreseeable. The plaintiff's failure to mitigate damages can also be a defense to remedies, as well as the typical defenses to equitable relief, latches and unclean hands. This is a very concise way to consider contracts, and as we go through the essay questions together, you are going to see just how important it is to have a very clear idea in your mind about how to think about contracts before you actually get into the nuts and bolts of trying to outline and write winning answers to contracts essay questions.